Next up on This Week in Law, we've got Jerry Brito, Joseph Lorenzo Hall, Evan Brown, and myself. We're going to talk about IVTV and Aereo and why you don't have to have too much sympathy for the copyright claims against them. We're going to talk a whole lot about privacy and policy and have that policy discussion that you've been looking for in the weeks running up to the election. We know you care about these issues. We're going to talk about them next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise, Howell, and Evan Brown. Episode 184, recorded October 19, 2012. Weaponized mice. This episode of This Week in Law is brought to you by ShareFile. Enhance your workflow, send files of almost any size easily and securely with ShareFile by Citrix. Try ShareFile today. For a 30-day free trial, go to sharefile.com, click the radio microphone, and enter TWiL. Hi, folks. I'm Denise Howell. Thank you so much for joining us for This Week in Law, where we have great talks each week about technology and the law. And particularly this week, we're hoping to have the tech policy conversation that's been missing in the presidential and vice presidential debates we've all been listening to. I've certainly been waiting for that topic to come up, and it hasn't at all. So we're going to try and fill in that gap. We have a couple of policy wonks and experts joining us this week from Arlington, Virginia, and the Mercatus Center at George Mason University. We've got Jerry Brito. Hello, Jerry.
Hello. How's it going?
Going great. Great to have you on the show.
Thanks for having me.
Our pleasure. Also joining us from D.C. and the Center for Democracy and Technology is Joe Lorenzo Hall. Hello, Joe.
Hi, everyone. Thank you very much for having me.
Joe is the senior staff technologist there and an uber geek, as I noticed when I reviewed your resume, a la the Big Bang Theory, illegitimate astrophysicist joining us here today. So thrilled to have you.
I have a lot of atmospheres, yes.
Wonderful. I'm sure that will really inform our discussions today. Let's jump right into, I'm sorry, I've yet to introduce one of the most important members of our family, Evan Brown. Hello, Evan.
Well, thanks, Denise. It's great to see you. Thanks for not forgetting about me. I always have that existential angst, when that happens. But, I'm really relieved that we're going to have this tech policy discussion because, it's really gotten confusing in my inner monologue with all this stuff. So it's great to, be able to share some of these thoughts today. So it should be a lot of fun.
Yeah, it should be great fun. Particularly because we've got two such smart folks joining us, and Jerry has been writing some great stuff, as has Joe. So we're definitely going to touch on some of their recent work and just lead off with, Jerry, you had an argument why copyright shouldn't be a tool for broadcasters to use to shut down people like Ivy and Aereo, an argument I hadn't heard before that really rang true to me. Why don't you bring us up to speed? First, for anyone, I'm pretty sure that almost everyone listening to the show has probably heard our past coverage of Ivy and Aereo, but just to bring anyone up to speed who might not know who those are, why don't you tell us who they are and then lead into your theory?
Well, so Ivy and Aereo are internet companies, and what they do is that they take a broadcast signal. So these aren't cable channels like CNN or MSNBC or ESPN. These are your regular NBC, CBS, Fox affiliates that are broadcasting free and clear over the air. They capture those signals with an antenna, just like you would at home, and then they rebroadcast over the internet. And what you can do is start an account with them, and for something like $5 a month, you can log in whenever you want and watch NBC, CBS, ABC, or Fox television shows. And there's even oftentimes there's a DVR component associated with that, so you can sort of set to record and then watch a show later. And as you can imagine, the broadcasters, but also the content owners of the programs, have sued to stop them from doing this. And this is a very kind of complex area of the law. it seems that most areas of the law are complex, but this one's particularly complex because you have several interests here. One is the broadcasters. The broadcasters have their signal, which is being taken and rebroadcasted, and then you have the content owners, which have copyright over the programs themselves, and they're both suing. So I was focusing in on the broadcasters, and so Ivy is a company that was sort of put out of business. They lost their court case, and they've since shut down. Aereo is a company in New York that is still operational, and in fact has been winning at least the first argument in court. And quite simply, what they've done is taken copyright arguments and said, you are taking our content and you are rebroadcasting it, and you shouldn't be able to do that. And the argument that I had is that somebody was saying, broadcasters, the reason that they are able to have free over-the-air television for citizens is because of copyright. And I was pointing out that, in fact, no, that's not really the reason why broadcasters pursue free over-the-air broadcasting. The reason they do is because they have to. It's a condition of their license, their spectrum license. They are given spectrum for free, which is it's a very valuable input to their business. It's being given to them by the FCC, by the federal government. And as a condition for having that free spectrum, they have to provide their broadcast signal free and over the air. And the way I see it, and certainly the way that Aereo operates, all Aereo is a really long antenna, right? And Aereo, actually, the way that they operate, it's kind of ridiculous that they have to operate this way, but every user of Aereo has its own tiny antenna, right? So it's not as if Aereo has one big antenna that captures a signal and then rebroadcasts it out to its thousands of subscribers. It has thousands of little antennas, one each for each subscriber. So it's the same thing as if I put up an antenna in my roof. Basically, Aereo has an antenna for me, and I'm simply accessing it over the internet. Now, in an ideal world, in my mind, we would have spectrum be privatized. And if you had privatized spectrum, you wouldn't see over-the-air television. You would see probably all sorts of other models that we can get into. But to the extent that we're not going to have that system, I'm really not crying for broadcasters. I'm really not shedding a tear for them when they complain that their signal is being used by citizens who, have a right to put up an antenna and do it. If they put an antenna on their roof, they should be able to do it using the internet as well.
Did Ivy forego the individualized antennas? It's been so long since I looked at their actual tech. I can't remember.
Yeah, I can't remember either. I think Ivy may not have had individual antennas. They're a company based out of Canada, if I'm not mistaken. And they were taking signals from Seattle and I think New York. Whereas Aereo is a company that started after the Cablevision decision, in which I think it was the Second Circuit, if I'm not mistaken, said that Cablevision's DVR, sort of remote DVR, where consumers didn't have one DVR in their home, but basically had the equivalent sort of hard drive space at the head end, at the cable company, that was okay as long as every consumer had its own sort of space. So if you wanted to record Big Bang Theory, it would just get recorded once and sent to everybody who wanted it. It would get recorded 1,000 times for 1,000 customers. So since that decision sort of opened the door for this, after that, Aereo came in with its business model. So I think Ivy, I really don't know, I'd have to look it up, but I think Ivy didn't have an antenna for each person. Yeah, that's my recollection. And in your blog piece about this here, you've pointed out a 1968 Supreme Court case called Fortnightly that basically validated cable systems as one big long antenna, didn't it? They did, but that has since been changed by Congress, right? So this was when cable was in its infancy. Literally, it was called community access television, right? And what cable operators would do, this is before there were dedicated cable channels, before there was a CNN, before there was an ESPN, they would simply put up an antenna on top of a mountain and get the signals from the local broadcasters, but also from distant broadcasters. And they would then retransmit those signals over to, especially where there were communities that were either far away and didn't get good reception, or where there was like a valley and it didn't get good reception, and it would resell this service. And of course, there was no law on this, and the broadcaster sued the brand new, this new invention, cable, and the Supreme Court said no, it's just a big antenna. It's just that there's an antenna on a mountain somewhere, and there's a cable going all the way to somebody's home. But soon after that, Congress passed legislation that required, and it's pretty convoluted, but requires either consent from the broadcaster, or sometimes the broadcaster can require the cable operator to carry its signal.
And that legislation is also where we see the definition of a cable system, right? That was implicated in. So I would have a follow-up question on that. I mean, I don't want to oversimplify things, and so I'm risking oversimplifying things a little bit. But Jerry, I would pose the question to you: would you take issue with the court's finding in the Ivey decision that what it was doing is not a cable system as it's defined under the Act? Because that certainly was a part that I had trouble with in that opinion, saying, well, the court just seemed to be – it had decided before it even sat down to actually think about it that it was not going to be, and it kind of made this stretched analysis saying, well, it's the internet, it's everywhere, it can't really be a facility, it doesn't have four walls like the Comcast offices do, I guess. Am I oversimplifying it, or is there anything in what you're saying that's embodied by that?
Well, I mean, the thing about that is you could probably read it either way, and I think you could make a fair case either way. And so I don't think the court was sort of out of bounds by deciding it that way. The problem is this is the Cable Act. If I'm not mistaken, that was 1992. So, before really the commercial internet had really taken off. And so it probably wasn't contemplating a service like Aereo or Ivy. And so if you look at the language now and you try to fit it into, you try to shoehorn it into a bucket, you could probably make a case either way. I think something that we should point out, though, especially if we don't want to oversimplify, is that we're not just talking about broadcasters here. We're also talking about the content owners. And there I think that they have a much better claim, right? Because if you are the producers of Big Bang Theory, right? So you sell it to CBS and they put it on their stations. But you're not sort of agreeing to have that on Ivy. So they might have a better claim than the broadcasters themselves. Something else we should also keep in mind.
Joe, I know that the CDT has followed Ivy and Aereo. Is there anything on your mind as you consider Jerry's argument that perhaps copyright shouldn't be the basis for their being able to put these new kinds of carriers out of business?
Excuse me. Certainly, I'm a big fan of shifting of all sorts in the copyright sense. But, I think Jerry makes a good point that there are fora in which it's not just copyright that's the governing element here. And here we have a scarce resource, which is spectrum, right? And that there is more of a negotiation that takes place there. I'm not familiar with my own I've been here for a month and a half, so I apologize. I'm not familiar with our own position on Ivy and Aereo, but I definitely think that by copyright holders, by allowing certain kinds of shifting, it seems like it's hard for them to anticipate the risks involved with that. But I think it's equally hard, and I think Jerry's made this point in the past, it's equally hard to anticipate the benefits you might get from that. Like you might get sales that are hard to predict for other channels by doing those kinds of things, and that sort of unpredictable but undeniable source of benefit seems like something we can't really deny here. Sorry, I don't have more to say about it. This is not something that I'm particularly well briefed in.
Right. The way you've couched this, Jerry, is that you have little sympathy for the copyright claims. Do you think that a court would feel similarly? I mean, they certainly don't evaporate simply because we're talking about the scarce resource of spectrum that they're given for free.
No, and I have to make clear, what I'm making here is sort of a normative argument. I think that probably the Ivy case was probably decided right. With Aereo, it's going to be more interesting because you do have that sort of Cablevision precedent. So we'll see how that goes. But what I'm talking about simply is normatively, the broadcasters sort of are saying they're taking our content, but they have to understand that they're getting an input, a major input into their business spectrum for free. So they want to double dip. They want to get free spectrum on one end, and then on the other end, they want to use copyright law to prevent people from accessing their signal. Right. So if the quid pro quo is the U.S. government gives you free spectrum in exchange for you making your signal available to anybody with an antenna, well then you can't later turn around and use copyright law to back out of that. Now, I think the law probably is there in a way where they could arguably stop that. I'm just saying that I don't feel sorry for the broadcasters who are having to confront this. And more importantly, the system we have today for allocating spectrum is ridiculous. What happened was that in the 1940s and 1950s, when we started to allocate spectrum, people started to put claims on spectrum just by simply putting up a radio tower and broadcasting. But soon enough, the federal government sort of took it over and said, no, we're going to allocate it ourselves. And so the FCC, first was the Federal Radio Commission, then it was Federal Communications Commission, came in and said, we are going to allocate spectrum ourselves. And where we're going to do it is that we're going to have comparative hearings. And what that meant was basically that if you wanted to put up a TV station, you would go before the FCC and you would present evidence at a hearing about why you were the most fit person to have a TV license. And so different people would compete, and ultimately one would get the license, a very, very valuable thing to have. And of course, TV was the hottest killer app of the 1950s. And that's where we put so much of our spectrum. Now, fast forward 50 years, and we're now in a place where this legacy system, the legacy technology has all of the best spectrum. When it's now a dying technology. I think it's like 90% of Americans don't get their TV from over the air. They get it over cable, satellite, fiber, or something else. So we have all this wonderful resource sort of held up by these folks who have this legacy technology. If we hadn't simply had the government allocate the spectrum and just handed it out to who they thought would be best fit, et cetera, if we had simply privatized it and had property in spectrum, well, what would have happened? What would have happened is that the technology would have been traded, the spectrum would have been traded little by little, and you would have seen a shift of spectrum being put to its best use. And today that probably would be simply wireless broadband, IP, over which you could receive any signal, whether it's a video signal or an audio signal for a podcast like this, or for just text or whatever else.
Yeah, it's a really interesting world to imagine. And I'm sure that most people sitting back on their couches and clicking on their cable don't think about the fact that they're watching, 40 years of spectrum being allocated out in a way that is not the way we do it, for example, with the wireless companies. Evan, any final thoughts about this?
Well, I'm really glad you talked about privatization of spectrum, Jerry, there at the end, because like I'm sure a lot of our listeners and our viewers are as well, I was a bit uninformed as to how it would actually work. So if there's anything I would want to follow up on, it would just be exploring the mechanics for that. Because it seems like at a basic level, there would still need to be an enforcement mechanism where the government would play an important role in that. If we're going to treat spectrum as property, I guess my question to formulate a question of this would be: would we look at misuse of spectrum by somebody not authorized to do it? Would we look at that in the nature of an infringement or some kind of trespass onto another part of the spectrum? And would there be, if we had privatized it or left it, set it up as property long ago, is that the kind of cause of action we would be seeing for the misuse rather than using it outside the scope of a license that's granted from the government? I think that's an interesting concept to explore. I wonder if you have anything about that.
Yeah, I mean, so Congress and the FCC, I think, are finally understanding this. And so, in fact, we are moving in a direction where we are trying to get the broadcasters to take the spectrum that's not dedicated to broadcasting and have that moved over to its highest value use, which at this moment is broadband. And the way they're doing that is that they're having voluntary incentive auctions. And what this means is that any broadcaster, right, either local channel 3 or whatever in your area, can decide to put up its spectrum, sort of opt into a process by which the FCC will hold an auction. And anybody can bid on it. Well, not necessarily anybody. There's all sorts of rules about who can bid. But you can imagine who's going to be bidding in this. It's going to be AT&T and Verizon and Sprint and T-Mobile and who knows, maybe Google. And the highest bidder wins the spectrum, and then they can put it to whatever use they want, to a more flexible use than what we have now. Right now, the licenses that exist require you to do over-the-air TV. These new licenses presumably would be more flexible, so you could do broadband or something else in the future if it becomes the better technology. And the point is that the highest bidder wins, and the money that is collected from that goes to the federal government, and in part, though, also shared with the broadcasters, which is pretty interesting. Remember, they never paid anything for this at the beginning, but at this point, after 50 years, the stations have changed hands so many times. There is somewhat of a claim there that they should get some of that revenue, and that's why it's voluntary. So that by no means is full privatization, because you still what you're still auctioning here is a license. It's not a property right. But if you did have full privatization, it wouldn't be too much different. It would just require less permission, having to go ask permission from the FCC anytime you wanted to do something different. If there was some trespass, as you mentioned, if you were interfering with somebody else's signal, you could take that to court, and you can get that resolved. I mean, we could make the FCC sort of a technical court that resolves those kinds of disputes. It really would be. I mean, spectrum is a scarce resource, right? But so is paper, right? And we don't license the New York Times to print a newspaper, right? They go in the open market and they buy their paper, and they do it fine.
Or they buy their server space to put their stuff behind.
Same thing.
Yeah. Yes. Yeah, it's a really interesting concept. It's so important because it affects, how not only we all communicate, but how we have discourse about the political process in the country and, receive our news, everything else. So it's terribly important, and I really wish that we had seen more of this come up in the political conversations leading up to the election, but no such luck. In addition to Ivy and Aereo, who are companies who are now asking for forgiveness as opposed to having asked permission, maybe they don't feel like they needed permission because they have their various legal arguments why they can do what they're doing. Pinterest is kind of in the same boat and is a company that we've talked about here in the past because it has angered so many for the way that it brings in others' content and archives it and redisplays it there on the Pinterest site. They have been making some headway in forging partnerships with people. Now, taking sort of the copyright devil's advocate side here, the quote-unquote partners of Pinterest might feel like they've been extorted into this, right? Because their works are still being used. But what Pinterest has been offering them is the ability for them to create an API, which Pinterest can then use. And if they do so, they will find themselves getting attribution and a link back when their content appears on the Pinterest site. So Dreams Time is a stock photo site which has recently signed up for this, created such an API. Others over the last year that have come on board include Flickr, YouTube, Behance, Vimeo, Etsy, Kickstarter, SlideShare, and SoundCloud. So this is just a new one joining onto this scheme of Pinterest's here to make partners as opposed to litigants. Evan, what do you think of this strategy?
Well, there's one thing that's a little bit bizarre about this, and it is that the discussion seems to begin from the premise that if there's attribution given, then the liability for copyright infringement is absolved. Now, what we see here is companies, platforms like Dreamstime and the other platforms that you mentioned on that list there, they're partnering up with Pinterest. But it seems to just be strange to me that it's hard for me to believe that there hasn't been any litigation over this, that somebody hasn't filed a copyright infringement lawsuit. I'm surprised Perfect 10, for example, hasn't filed a copyright infringement lawsuit against Pinterest, because what we have talked about almost to ad nauseum here is that Pinterest actually does create another copy of the content, and that it clearly is a prima facie example of infringement. And so what I just find a bit surprising is that the remedies, the things that have ameliorated these concerns appear to be just, okay, well, implement an API on your end, partner, this is Pinterest talking, and, we will provide you attribution, and that's going to make the copyright infringement issue go away. That's the strange thing that sounds to me, that I hear in this, and I'm just surprised there hasn't been a bigger dispute over the fact that there really is infringement going on here, and this seems like only a halfway satisfactory answer when you're thinking of it in terms of copyright liability.
Right. The other thing Pinterest has given folks to implement is their no pin code, which they say that they will honor. So if you're running that, then presumably your stuff cannot be added to Pinterest. I'm not sure how that all plays out or whether there have been issues there. At the end of this TechCrunch piece from Sarah Perez, a spokesperson from Pinterest, says, discussing how the attribution and the link back system is not perfect for folks like Dreamstime, because when you click on the image, it's actually going to link back to perhaps the blog of the person who posted the image, which is not the actual, Dreamstime site. There's no guarantee, in other words, that you're going to link back to the actual source. You could be somewhere several drifts down the stream from where the source material came from. Pinterest is sort of shrugging at that, saying that we can't control if someone right-clicks on an image and saves it to their blog. This is a limitation of the internet. And then they don't go on to say, and this is why we have the DMCA. You have a problem with something on our site, you can send us a notice, and if it is infringing, we will take it down. So they are continuing to forge ahead. Jerry, any thoughts about Pinterest before we move on?
Yeah, it's what you last mentioned about the DMCA, I think, is really the key here. I think Pinterest is sitting pretty here because this is all user-generated content. They're not providing this content. Users are uploading it. And under the DMCA, they're not responsible for it. They're responsible for if one of these stock photo companies sends them a DMCA notice for a takedown, they do have to respond to that. But short of that, I think what they're doing here is it's nice that they're giving at least this option to have this attribution. I know that the Tumblr actually started doing this at least over a year ago, I think, where I'm not sure if they require the third party to have an API. I think they just sort of parse what the URL is, and if they see, okay, this is a New York Times article, they add the NYT logo and a link back.
Jerry,
right,
was
Jeff?
that any features in that in any subsequent iterations of your Tumblr? Weren't you the first to create a Tumblr iPad app? Isn't that
that's
in your
right? Thanks for bringing that up. Yeah, we my partner Pete Snyder and I were the first to have a Tumblr application for the iPad. Unfortunately, we recently had to take it down from the App Store because this was a big story in the Tumblr sort of world a couple weeks ago. Tumblr changed its API and didn't bother to give any warning to any of the developers. And so I know, and all of the login broke for everybody. They moved to OAuth when before it was pretty bad. It was sort of like plain text passwords were sent. And so they moved to OAuth. They didn't tell anybody, and it broke our app. So rather than sell an app that didn't work. We took it down from the App Store, and we're working to maybe get it back up.
That's awesome. I'll have to check that out. Joe, any thoughts on Pinterest?
Sure. Basic thoughts. Section 512 of the DMCA, that safe harbor is just such that, and then Section 230 of the Communications Decency Act. That I think we can ascribe a lot of wonderful things and somewhat, less wonderful things on the internet to those parts of the law, and I'm glad to see companies like Pinterest, going sort of an extra step with these sort of voluntary measures, this no pin code, which is very similar to, you have a no follow piece of metadata you can have on link structures that make sure that Google, won't sort of promote comment spam in its results and stuff like that. So I'm glad to see that, the law and policy is working well, but there's also some sort of additional measures to increase the technical help that people can use and to sort of do some of that metadata stuff. Personally, I license all my stuff as Creative Commons attribution, so I can't complain very much when people use my photos and videos in some other place. But I do follow up with people and say, that thing in your brochure, I've seen your brochure around, it has my picture in it, especially in the voting space where I've taken just tons of pictures of voting machines and they end up getting used quite a bit. I do like that attribution just because, I took the dang thing. I'd like to see some link back to the original metadata where people can ask me for higher resolutions. Maybe I have other pictures they might want to use. And so for me as a creator, it's more about making sure that people have very high quality content, and that there's a possibility of a conversation between myself as a creator and people that might remix or reuse my works. So that, I guess that's all I'd say.
It seems to me. Go ahead, Denise.
No, you haven't.
It seems to me that it would be relatively simple in the scheme of things to develop a technology at least analogous to what YouTube does with Content ID for these images that show up on Pinterest, especially in those instances where the link is being made to another place other than the original source of the content. So what Pinterest could do is maintain a database that has a certain digital signature of a particular image, and if the link is not going to the URL associated with that particular digital signature, it could modify the link so that it goes back to the original image per, say, Joe, it's on your website, on your Flickr account or whatever, thereby paying you in the currency of attribution, much in the same way that Content ID allows the payment of actual dollars and cents to, Universal Music Group and others on YouTube. I wouldn't know how to actually engineer something like that, but it seems like something that could be done, and it would take care of this problem that is expressed about Pinterest here, and also satisfy the sensibilities of folks like you, Joe, who look to that attribution as being so critically important.
Yeah, and with reference to Content ID, this would be vastly more simple than Content ID, because with Content ID, you have to deal with moving images and audio and creating some sort of dynamic way of fingerprinting that, whereas with images, you can do a few different kinds of resolutions, a few little crops and stuff like that, and there are facilities online right now where you can put an image and it will tell you where on the internet that came from. And so there's that to a lot of, in a lot of senses that problem's sort of solved. They may be in proprietary tools. I think there's a few open sourcey kind of things that will do that kind of stuff.
I think Google even does it on Google Images. Yeah. If you have an image, you can see different iterations of it online.
Yeah. But I do want to stress that I don't think it's good policy to require companies to have to do that kind of stuff, because it can get into this sort of cat and mouse arbitrary sort of like, oh, well, you accommodated us by creating this crazy Content ID thing. Content ID is a really hard thing to do right, and there's nothing that says that Google or YouTube has to do that. And I don't want to. I don't think it's good policy to force that upon innovators and companies. And I think a lot of this can be solved just by the safe harbor mechanisms that are there, that promotes the most of the good. I do like to see, as a sort of as a diplomat myself and someone that often falls in the middle of these kinds of conversations, I do like to see accommodations made. But what I don't like to see is a slippery slope of, oh well, you did this, why can't you do something a little bit more? Because then it gets to be like, oh geez, death by a million, not exactly a million, but a lot of cuts that end up being 1% of revenue, another percent of revenue, or whatever. I don't know what it is, so I do want to urge some caution there.
All right. Well, as long as we're on the DMCA, just a quick side note here. I don't want to spend too much time on this, but it's a great example of how the law is valuable and allows, as Joe was saying, 1,000 flowers to bloom or several million flowers to bloom. But in its implementation, it can be difficult. There's a story by John Brodkin, who's going to join us on TWiL soon, next month, I believe, at Ars Technica, about Server Beach and an outfit called EduBlogs, which is based in Australia. And Server Beach hosts over 1.45 million education-related blogs for EduBlogs. They got a DMCA notice from someone called Pearson, who's an educational publisher, for one page, a questionnaire that was copyrighted by Pearson. That triggered a review, a notice to EduBlog saying, hey, there's this thing they're saying is infringing. Take a look. If it is, please take it down. EduBlogs did, but for some reason it didn't stop there, and all 1.4 million blogs came down from Server Beach. They were just trying to be super careful in complying with the notice. And Evan, you were quoted in this piece and were very careful to say they certainly didn't have to go this far. But you can see why they might. I mean, people are pretty shaken in their boots when they get these things from lawyers, don't you think?
Right, and I also was on Tech News Today a couple of days ago with Tom and Ayaz and Sarah and Jason talking about this very same story. And really, the bad players in this, or actually it's just in the singular, the bad player in this really is the copyright claimant, Pearson, in the first instance, because the work at issue here, it's one, I think it's just like a 20-question checklist that is years old, 30-some, 40 years old, on a blog post that was published on a rather insignificant page 5 years, or back in 2007, almost 5 years ago, almost 6 years ago, perhaps. And so by sending this and being so maximalist in its enforcement efforts over that's really the evil actor, I think, that's here. Yeah, they perhaps have copyright rights, but I have experience with Pearson myself to know that they are just way overzealous in the enforcement of their very thin copyright rights. Server Beach could have done things better, and I was quoted in the Ars Technica piece and reiterated this on TNT a couple days ago, that they were just being ham-fisted in all this. Now, it's not a simple thing technologically that they were being asked to do, disable one piece of content, even though it sounds in the abstract like, well, why did they take down 1.5 million blogs over one piece of content? Given the position that they're in as the upstream hosting provider of this, it wasn't just as simple as going in and deleting something off of a file like that. So Server Beach certainly didn't do the right thing, but since then they certainly have done the right thing by making it right with their customer, EduBlogs, which is a very substantial customer, them $75,000 a year or more on that. So, I want to be careful to not blame. Certainly, I don't think the DMCA is to blame on this because the DMCA requires copyright claimants to identify with a great amount of particularity the content that you're supposed to have taken down, and then there are those that you want taken down, and then there are the provisions in the DMCA that allow for aggrieved parties who are the subject of bad takedown notices to seek redress for that. So it's not the DMCA's fault, but I think one thing that we need to be aware of here is that if we get into a situation where SOPA or PIPA is the framework, that kind of framework that we're dealing with, then we would have to get used to whole systems being taken down over one piece of content, and that's not a good situation for any of us here. So the Server Beach situation with EduBlogs was unfortunate. It didn't have to happen. Efforts have been made to make it right since then, but this is only foreshadowing a rather grim future if regulation and the legal framework for this goes the way that a lot of copyright maximalists would want it to go in the future. So it's another reminder why we need to be vigilant about the way these things are going down the road.
Definitely is. Hey, Joe is going to have to leave us in a few minutes here. And before, maybe we'll get him back. We hope to get him back after he takes care of some real-world business obligations. But I want to get to a couple of his things before we've got to let him run. And the first is on the privacy front.
Dong.
There it comes.
Something like that.
Just waiting for those dulcet bass tones. Joe, you wrote a great piece over on the CDT site on Apple iOS 6 and privacy. This was our tip of the week from last week, is how to go ahead and put on those limit ad tracking services in iOS 6. I'm not sure how much of the drafting of this you did. You're the co-author with GS Hans. But whoever drafted it is being very, very politic when they say it's unclear why this setting is located outside of the privacy settings and deep in the general settings. But its existence and functionality are welcome. One thing we did not discuss when we talked about how to flick this setting on and limit ad tracking is the extent to which you are limiting tracking. What exactly is being limited here? Do you know?
Yeah. So I definitely did most of the drafting, but Gautam, our Plesser fellow, helped out quite a bit, especially the screenshots with his new iPhone 5, which is a crucial part of that piece.
Right.
So what's essentially happened is they've moved, Apple in iOS 6 is trying to be more privacy preserving, privacy protective, and has broken up the number of identifiers that are sort of available for apps and code to use to identify you as a device or a human. And there's one specific one called the Identifier for Advertisers, IFA. And it's built with this other piece that's sort of just a flag, an off-on kind of a thing that is the limit ad tracking setting you mentioned earlier. And limit ad tracking is sort of it's a preference, and I don't mean that as like preferences when you open up a program in your computer, it has all these settings or whatever. I mean, this is you're expressing a preference that you do not want to be tracked for advertising purposes. And the way it works with Apple is if a developer sees that you have that flag set on, which means you want to have ad tracking limited for yourself, then there's a very narrow set of things that they can use that identifier for. So that doesn't turn off the identifier. It basically says, right, look, you can only use these for very, very narrow set of things like security and abuse kinds of things, or some things that no one sort of argues with as a bad thing, like frequency capping, which is a fancy way of saying we'd only want to show you an ad a small number of times because you're probably going to get really pissed off if you see it, 8 times in a row, which has happened to me when I watch things on Hulu. I think they have something broke there. And so that's essentially what it is. It's sort of cabining a bunch of non-controversial, narrow uses for an identifier. And CDT is very glad to see that, and glad to see that they don't include more expansive, more diffuse ones like market research, product development, or maintaining the customer relationship, which are things that are not terribly well defined.
Yes, I was worried about that. The term limit ad tracking as opposed to turn off ad tracking is somewhat ambiguous. So I'm glad to have you clarify that. I'd love to have you, too, before you have to run off, tell us a bit about online voting. We're coming up to our 2012 presidential elections, and I just sent in my paper ballot. Why do I have to do that, Joe?
Woo! I'm very glad to hear you have voted. Hopefully nothing will happen between now and the election that would cause you to change your vote.
No.
But as a lot of us know who work a lot, there's an increasing number of convenient ways to vote. There's a lot of early voting where there's extended hours, a couple of weeks in some places before Election Day, where you can go and vote in a gigantic wholesale polling place kind of a thing. But there is sort of pressure right now being placed on everyone that's involved in elections to allow forms of online voting, especially for overseas and military voters. You can imagine military, someone in the Marines or someone in the Army in Kandahar, Afghanistan, or even farther out, in doing operations. Or the great example is people on radio silent nuclear submarines that don't come up for 6 months. How do they vote? Unfortunately, in a lot of cases, they don't. And this is not a good thing. We want to make sure that the people that are out there, serving our country can vote. And unfortunately, the solution ends up being electronic return of voted ballot materials, which is a fancy way of saying it's not a piece of paper that gets sent back. It's not a physical artifact. It's some sort of signaling. And a lot of people tend to say, well, if it's safe for me to bank online, why can't I vote online? That's sort of, in one sense, that's a straw man, because people who have a little bit more education know that it's not exactly as clear cut as that. It's not safe for you to bank online, and it's increasingly more unsafe, but you can buy insurance for things like online banking. There's no insurance for failed elections. You end up having to do them over again.
I thought moving to Canada would be the only kind of insurance there, right?
Well, that's an interesting point that, no country, first of all, no other country has a free market for voting technology that election administrators have to buy from. It's usually just a bidding process, but no other country has the problems we have with voting. And Jerry actually interviewed me for his podcast a while back, and we went through this in laborious detail, so he might be falling asleep. But one of the things that I think it's we can point out, like in a place like Canada, you vote for one member of parliament, whereas in California recently you voted for federal, state, local, sublocal. You have mosquito abatement districts in a place like California, or Miami. If you live in Miami, you'll have a 9-page ballot. And these things can be, that means that things get very complicated, but it also means sort of from a security perspective, the attack surface, the amount of opportunities for vulnerabilities to arise and to be exploited ends up being rather large. And you can imagine the Tony Sopranos of the world, aren't really interested in necessarily affecting the presidential election, but that, waste management bond that's a couple $1 million, that might get passed and they might get hired. No one's going to look at that in a lot of detail. And those are the kinds of cases where when you move to the online context, I know a lot of really wily hackers, some of them in places where we don't have very good extradition relationships with, that, would love to be able to hack an American election and actually prove that they've done it. And I'm really hoping that, I don't want to see that happen, but it might be that, you often get the arguments in voting that, we've never seen this kind of attack happen before. Well, I've never been in a car wreck, but I don't, buy car insurance. I've never been in a car wreck, but I still buy car insurance. It's sort of this past performance is not a guarantee of future results. It's risk management and security is especially difficult because you have an adversary. It's not like earthquakes that happen according to some predictable function. It's really sort of, if you awaken the dragons may show up, and it may really not be so much fun. And, the constitutional issues with the presidential election are fascinating too. There's a bunch of congressional research reports that show that it's actually really hard to ever do a do-over of a presidential election, especially with enough time before the electors are required to meet according to the Constitution.
All right. Well, we'll check back with you on this in 2016 and see if we've made any progress. In the meantime, we're going to let you run. If you want to come back in, please do. You're more than welcome to come back before we wrap the show. We hope to see you again. But if we don't, folks, you can find Joe at the Center for Democracy and Technology. He is Joe B1 on Twitter, and he's got a G+ account too. It's great to have had you on, and we hope to have you back either on this show or another one soon.
Thank you. You guys rock, and I'll try and get back on if I can get this business done quick.
Great. Okay, we'd love to have you. All right.
So Denise, even if you were to see one of these binders full of women, that couldn't have changed your vote, between now and the election.
I have one right here. Binder full of women. Binder from awesome. Blog Her. There you go. They exist. Actually, binder full of stuff of interest to women, I guess that would have to be. But yeah, let's talk about that in a little while. Or I don't know. Let's talk about it now.
It's never a bad time to talk about binders full of women. Never a bad time.
Actually, let's save the binders full of women. It's such a fun topic for, let's thank our sponsor for this show, which is ShareFile. And then let's talk about binders full of women in a minute. ShareFile is our sponsor for this episode of This Week in Law. Now, of course, technology has changed the way we all work, but in order to make the most of it, we need the right tools. That's why I use ShareFile by Citrix. Industry professionals in law, accounting, financial services, healthcare, marketing, and more rely on ShareFile every day to collaborate with clients and coworkers while maintaining the highest level of security and accountability. This is very, very important because with ShareFile, you can send and receive files of almost any size. And instead of attachments, they're sent as secure links. There are no bounce backs. You'll never exceed someone's inbox space. It provides you with complete control over who has access to files, and it offers features like password protection for optimal security. Plus, with ShareFile, you can access files from anywhere, your laptop, your tablet, or your smartphone. So it makes a great way to take your office mobily on the road with you as well. Now, for me, I find this incredibly important in today's economy. You are looking at my law office right here. I am a sole practitioner. I am in my office. The resources I have are what are in front of me. And I'm so grateful that those resources include ShareFile because I don't have to have an extranet for my clients. All I need is ShareFile. I can customize the page such that they know that they're dealing with me in my professional capacity. They know that everything there that we're sharing and collaborating on is secure, and they know it's going to get to them. They don't have to query whether, hey, Denise, did you ever send me that great big media file? Because it doesn't seem to have come through. They're going to get these large files that otherwise they might not have been able to access. And they're going to get them in a way that's confidential and secure. When you're practicing law, this is extraordinarily important. You can't breach client confidences that way. Not only can it damage their business, it can damage their legal position in litigation if you waive the attorney work product or client privilege. So you have to be super careful with that. And I'm really grateful there's something like ShareFile that helps me do that in my own practice. So I want you to try ShareFile with my special offer. Sign up today. You'll get a free 30-day trial. Go to sharefile.com, click on the radio microphone, and enter TWiL. Remember, visit sharefile.com and type in TWiL. Thank you so much, ShareFile, for your support of This Week in Law. All right, so we've got binders right here in River City. I got to say, I listened to the debate. I listened to this segment of the debate, and it really just kind of washed over me. I mean, yeah, it was borderline rankling, but it didn't appall me the way it appalled so much of the internet. Maybe I've just been spending too much time with older white gentlemen who think like Mitt Romney does about women in business. But I'm used to hearing people speak this way. And it kind of surprised me that others didn't pick up on things from the debate, like him saying that if you were an illegal immigrant and you have children, they could stay in the U.S. if they do military service. Sort of flies in the face of the 14th Amendment if they're born here, where you automatically get citizenship. But that seems to have just kind of lost all the attention to the binders full of women.
You're just so serious. You got to get all constitutional. Can't it just be fun?
Yeah, I guess that binders are more fun than children in the military. That's for sure. Evan, how about all the remixing of this? Do we have some sort of tech law angle on this fun story?
Well, if we didn't, I was bound and determined to make one up, to go with this because this was just so funny. And I guess one interesting observation off the top of it, what was the debate? Monday night, so we're like 4 days out now. It's really funny how the half-life of internet memes gets shorter and shorter and shorter. I don't know about you, but this seems like old news already, even though it just happened, a few days ago here. So a couple of observations. I mean, first of all, the domain name thing, the domain name was snatched up within 90 90 seconds by this Democratic super PAC, Yay, Citizens United, called American Bridge 21st Century. And I just the Chris Harris, the communications director of that, I loved his quote in this CNN Money piece. Says, "We were sort of on standby, knowing that internet memes like this can solidify within seconds." Yeah, it certainly did. The domain name was registered within a couple of minutes, and then this Tumblr site, this Tumblr account was set up, bindersfullofwomen.tumblr.com, bringing in a bunch of user-submitted content here. And this is another angle we can take on this, talking about how awesome remix culture is. People taking images from other places and putting text over them. You know, just an hour or so ago, there's a picture of Bill Clinton with a real charming kind of expression on his face, and it says, "Stop the debate. I want to hear more about this binder." You know, that's Bill Clinton for you. You know, early on there was one with Hillary Clinton holding her smartphone and probably a BlackBerry. I'm not sure, and she had
I'm pretty sure it was a BlackBerry.
Yeah. And what was in the text overlaying it was Mitt still uses binders, LOL. So that was really funny. So if we were to look at this, and if we were without the protections in copyright law of fair use, that because of there it is. If for those of you who are watching on video, that's on the screen right now. That one of Hillary Clinton.
I'm with Hillary. I was hard pressed to find any binders in my office.
I work at a law firm, so I came in the next morning looking at some of the binders on the assistant's workstation out in front of me, and then I opened them up. There were no women in them, unfortunately. So, whatever. And so, we're talking about the copyright issue here. If we were without the protections of fair use, because these are parodies and satires like this, we would be deprived of this wonderful source of entertainment and interesting and important political commentary that is afforded by Tumblr accounts such as bindersfullofwomen.tumblr.com. So that's the angle, the sociological angle of it all, in as much as the intellectual property and all that stuff plays into it. It's an interesting little thing to see play out here.
It is indeed. Jerry, what do you think about all this?
Well, first, I just want to say that to be fair to Mitt, his plan actually is not it's not about children born in this country. He's talking about children that were born outside of the country and then brought here as children by their parents.
Yes.
They really didn't have a say in the matter.
I got that when I went to the issues page for the campaign. He didn't make that very clear in the debate.
Right. So yeah, what he's doing is actually more like a Dream Act kind of thing. What to me was so interesting about this is that even though that super PAC spent, I guess they just registered so they didn't spend too much, but even though they went through all this trouble to buy that domain name, bindersfullofwomen.com, that really nobody, I don't think anybody, I hadn't even heard of that domain until I was reading about it for the show. It was the Tumblr account that really is at the top of the Google ranking. It's one everybody's passing around on Twitter. It's really the focal thing. So it really goes to show, really, domain names, how little they matter now. It's where you are at the top of the search ranking. Right.
I just want to jump to my calendar page for TWiL here and let you know if you are interested in this Binders Full of Women issue and the discourse.
Who's not?
Yes, exactly. Not just the humor of it, but the actual underlying social issues here. We're going to have Joan Williams on the show on November 9th, and I'm hoping to get a good guest to join her. She's with the Work-Life Law Center at University of California, Hastings in San Francisco, and follows these issues very closely. So we're going to have a more substantive discussion with her on the issues of women in the workforce and technology. And, it's been supposed to liberate everyone. We can all work wherever, whenever, however we want to. And Mitt or others can send you home to make dinner for your family because we know that the work's going to get done. But we're going to talk about how that has all played out in the real world with Joan and hopefully another great commentator to join her. Still working on the booking for that show. Right now, let's go back to some privacy stories. We talked about iOS and privacy. Verizon has been in hot water about its plans. It has been going out to advertisers and saying, hey, we have all this great information about users. You have no idea. We know when they're sleeping. We know when they're awake. We know what they're watching. They're worse than Santa. And they want to sell that information to advertisers, which has not been getting them much positive attention. And in fact, has folks like the EFF and Declan McCullough wondering whether they are violating both federal wiretap laws and federal privacy laws. Evan, how do you think Verizon's doing here? Are they on thin ice?
Well, I have a feeling that Verizon isn't the worst culprit in all this. It's just that this is in the news this week. Declan McCullough wrote a great piece, which is customary for him to write great pieces over on CNET that came out on the 16th. And I guess this is, it's not news that Bill Diggins from Verizon, he's the U.S. chief for Verizon Wireless's marketing initiative. He spoke at that conference back in May where there was some attention given then to this quote that he made, says, "We're able to view just everything that they do," talking about the users. Well, technologically speaking, Verizon is absolutely not the only one in the position to be able to do that. But I guess the reason that this is in the news now is because it's actually begun capitalizing, monetizing this information that it collects. So it is definitely a pretty nuanced question as to whether Verizon is violating the Federal Wiretap Act, for example, on this, the Electronic Communications Privacy Act, which prohibits one from intercepting, among other things, electronic communications. And the definition of electronic communications under the Act on its face would appear to cover the kind of information that is being collected here, even something as simple as a URL visited or something like that, even though it's technically not what we think of in the everyday waking world, the layperson lexicon of what a communication is. So the real question of liability under that would appear to fall under this notion of whether the customer has consented to that information comprising, including electronic communications, is being intercepted, and Verizon, of course, being well aware of this potential for liability, appears to say in its privacy policy and its agreement with its customers that customers consent to this type of information gathering. So, I think what we're left with is more of a theoretical discussion of how this could be a Wiretap Act violation. And that leads us to a more general abstract kind of conversation about, well, isn't that really unnerving to us? Doesn't this remind us how these privacy issues can really be irritating at a fundamental level? Because with what they're doing here, unless we had agreed somewhere in all of that small print signing up for this service, if it would otherwise be illegal, that's something to be concerned about and to raise that kind of concern in our awareness at a new level, a new opportunity for it here. So, going back out to even a more general level where these types of stories come as no surprise to us. We've talked many times on the show about the pervasiveness of data collection and how that has privacy implications. So it definitely should not be a surprise to us that this is happening here. And it's good that we're having a conversation about it and are aware of these things.
Yeah, and we're right back to policy issues that I wish were getting more play in the election season. Should a telecom company have the right to know, not just know all this about you, but then sell the data simply because they've put something in their terms of service? As you point out, Evan, you can't contract around things that are illegal to begin with. Jerry, what do you think?
Well, so first of all, let's make sure we understand that Verizon isn't selling information about particular users. They're selling aggregate data about users. And right. I know somebody like Bill Diggins probably speaking at a conference for marketers is going to be like Mitt Romney talking to a room full of supporters and say things inelegantly. But here's the thing, right? I don't think any of us want Verizon we don't want this to be illegal, do we? Because if it is, then what we're arguing for is for higher wireless prices that we're going to have to pay, right? Verizon can sort of subsidize our bills because they can sell aggregate data to marketers. So we just have to keep in mind that there is a trade-off here. It's not a free lunch. We can't just say make this illegal for Verizon to do and then not expect on the other end our consumer prices to go up. And the other thing that I thought was really interesting about this is to see the EFF and other privacy advocates sort of going straight to the Wiretap Act, right? And we understand about sort of technology outstripping law, right? And laws that make perfect sense when they're written, technology, they can't keep up with technology and to become pretty anachronistic. And we're going to talk about the Stored Communications Act in a minute, I think. And we know that what we should do is reform those laws to allow for what's common use now. It's interesting to see privacy advocates now, when they see an anachronistic law give a result that they like, in this case, sort of maybe, perhaps make this a wiretap violation, and Wiretap Act is pretty old, they're okay with that law.
Right. All right. Well, we're going to have to stay tuned to this one. There's an argument here in Declan's piece that let's see, I don't see any substantive difference between collecting content from one person and turning it over to someone and collecting it from multiple people, aggregating it, et cetera, and turning the aggregate data over. In the end, you're capturing the content of the user, and the question becomes, one of interpreting the Wiretap Act. Is that content protected? Is it a communication for purposes of that act? Yeah. And I think that's still an open question.
And in addition to that, I mean, even though this is not data about one particularized user, it's no secret that re-identification is not all that complex of a process. It may be a little bit more complicated than implementing a content ID system for images on Pinterest. But, I brought up Professor Ohm a lot in the last couple of years, and even on the last show I talked about him, and he's quoted in this article, or actually he's cited, a law review article that he wrote is cited in this Declan McCullough piece from the 16th. And so Professor Ohm has written pretty exhaustively about how easy it is with large data sets to re-identify someone. So the more information that is out there, even coming from disparate sources in different places, being dispersed to other places, there's a privacy risk, even though it's not individualized to one particular customer. And that's something that needs to be treated, even if it's not something that's going to fall under the auspices of the Electronic Communications Privacy Act.
Can I say that I'm familiar with Paul Ohm's work, and it's very interesting. I would also point you to the work of Jane Yakowitz Bambauer and the work that she's done sort of critiquing Ohm's work and definitely showing that it's not as easy as Ohm says that it is. And in fact, if you prohibit that kind of aggregated data sharing, you're going to affect all sorts of other aspects, right? So you can imagine, for example, these kinds of laws affect where, for medical purposes, discovering the spread of diseases, et cetera. It's very interesting. It's a little bit more complicated. I could probably get into now, but I would check out Jane Yakowitz's critique of Ohm.
Great. We will do that. I've been inviting Paul Ohm on the show, and I'm hoping to hear back from him. If we could get her on as well, that would be a fun show.
Yeah.
Definitely. All right. We are going to talk about the Stored Communications Act, as we did last week, talking about this Jennings case where, for anyone who didn't listen last week, the Supreme Court of South Carolina found that socially engineering someone's password to a web-based mail account and accessing that account did not constitute a violation of the Stored Communications Act because the email did not qualify as storage under that act. That's what Jerry was alluding to as the technology being a bit out of whack with the law. One point from last week, just to clear up, we were kind of speculating about whether this case could go to the Supreme Court. It can indeed. I felt pretty certain that it could, and then I looked up the Supreme Court rules that specify that, the Supreme Court can basically do what it wants, but it has various discretionary guidelines that it gives you for presenting cases that it might review. And one of them is if a state court of last resort has decided an important federal question in a way that conflicts with the decision of another state court of last resort or of a United States Court of Appeals. And as we were talking about, this particular case is at odds with a Ninth Circuit decision. So we might Go ahead.
I just want you to know, Denise, I believed you all along. If there was a question about what the Supreme Court will issue, grant cert on, if you say it's true, I believed you the moment you said it.
Well, I hope somebody, decides to petition the Supreme Court, because it would be nice to see this get some clarity. I don't know if the Supreme Court can do much with it, though, because it's the act itself that is a bit vague. What I wanted to ask you guys about, since we already kind of talked about the case last week and the email aspect, over on the VRM list, someone had a question about, well, hey, we saw this decision come out. How's it going to affect data backups, personal data stores like personal.com? You remember we had Jason Galper on the show. Seems to me if that is your business model, you're a little concerned about this case. What do you think, Evan?
Well, I could see that. I mean, it's still it's going to have to come up, under that definition of what it means to be in electronic storage. And I could see it going either way. If it's characterized where that is like your only copy of it, and that seems to be the practice more and more, not necessarily having a local copy of it, then there's going to be problems. There's certainly the argument that is in electronic storage is going to be subject to some attack there. So it's just reason number 974 why the Stored Communications Act and the Electronic Communications Act, and perhaps to only a slightly lesser extent the Computer Fraud and Abuse Act, all need some serious revisiting to bring these frameworks into the 21st century, where data is stored and transferred in much different ways than what they were 30 years ago, when going on 30 years when these statutes were first enacted.
So, Jerry, picture yourself as a Supreme Court justice. Someone does a petition for cert and the court has granted it. Are you just going to have to say what Evan just said? We've got to go back and revisit these laws? Well,
I mean, again, this is one of these laws that was put in place in a different time where there was no internet and there was no email like Gmail that basically, I know my wife has tens of thousands of emails in her inbox, right? Her inbox is her storage on Gmail. Mm-hmm. And so that just was not in the minds of Congress when they put this together. So a court interpreting the statute now has leeway to go really either way. And so I think that this is something that Congress is just going to have to address soon.
Yeah, definitely. All right, let's look at something that's been much talked about this week that has to do with the social web. And this will be a good opportunity for me to drop our first MCLE passphrase of the show into the show, and that's going to be Reddit troll. Over there at Gawker, Adrian Chen did a lengthy piece where he unmasked someone named Michael Bruch, if I'm saying that right. Michael has been anonymously doing some really kind of societally objectionable things over on Reddit for quite some time. And Adrian found out who he was and called him on it and basically put a stop to it, because if he couldn't be anonymous and doing it, he couldn't really be doing it at all. He lost his job, and that's kind of where things stand at this point. He's no longer trolling. He's out of work because of the really kind of offensive stuff he was doing over there. And we're left with considering, okay, so how about this community of Reddit that is run by its users? I have not gone over it. I'm not a Reddit person. I haven't gone over and used it. I've been kind of glad that, unlike some other TWiT shows, we have never put our stuff on Reddit, mostly because I'm not a Reddit user. And we do our show prep and stuff on Delicious and Facebook and Google Plus and elsewhere. So we've got this fellow being bounced, the Reddit community being up in arms. What I haven't gone over and looked at is if there's any kind of terms of service, any kinds of, could he have been kicked by Reddit? I assume he could have, but it's just kind of such a free-for-all. I'm not even really quite sure how it operates. Evan, can you shed some light?
Well, sure. I mean, this was a really interesting story, and what I love even more than the original story is the commentary that Cachefly did on it the day or so after. Well, I guess it was on the 15th, so it was a couple of days after Adrian Chen wrote his piece, and Cachefly was giving a little bit of perspective on it and poking fun a little bit about how people were so breathlessly enamored with the fact that this had happened. She was talking about how the internet cool kids, for example, Farhad Manjoo, think this is just one of the most important pieces about the web that has broken all year. So, it's certainly a notable story and a notable incident that gives us plenty to talk about from a legal issue and kind of a governance issue, because there's a lot of different things that arise from this, a lot of different discussions that could be had. I think one of the big ones is what people are calling a free speech issue, which really isn't a free speech issue in the pure sense, because we're dealing with purely a private actor, Reddit here, about what are the contours, what are the bounds that should govern what someone is permitted to say on a platform like this. And then there was a little bit of irony leading up to when Adrian Chen, before he actually published the story, which I believe was a week ago today when he actually published the story outing Mr. Bruch on this. There were these indications that he was going to, and then there were some subreddit moderators were cutting off access to Gawker links in the discussions on Reddit that these moderators were governing here. So there's the issue of the free speech or the free flow of information. There's the issue of what is a responsible platform like Reddit supposed to do, or I guess the better way of asking the question, what is a platform like Reddit supposed to do when it wants to act responsibly here? And we've seen some indications from Reddit that it's thinking these things through, how to handle in a better way the instances of controversial speech. There's no shortage of that on Reddit, and that Michael Bruch's his past activities are just a real dossier of some of the more the darker underbellies type of content, underage photos, sexually suggestive but probably legal photos of underage girls, rape jokes, a lot of racist type of content. This guy was just the archetypal troll when it comes to this stuff. So such a high-profile situation like this has given Reddit the opportunity at a platform level to consider what type of content is going to allow to be there. It has talked particularly about the issue of doxing, this practice of compiling a dossier of information about someone and to out them, which is what happened here to Michael Bruch, talking about how that is prohibited. It's going to be prohibited on the site, and that may or may not, in certain circumstances, be lawful to do that. So those are some of the issues that arise from all this. I know that there are even more. We could even talk about what is Reddit's liability for publishing this content that is perhaps authorized or even posted by moderators. Are they agents of Reddit so that they would lose Section 230 immunity? All kinds of neat ways to slice this issue up.
Right. All excellent points. One other thing I'd just drop in that you mentioned, Evan, is that the free speech mantra that gets tossed out when we have stories like this, it bears emphasizing for people who haven't gone to law school and haven't had this drilled into them, that free speech is something that applies to what the government can do. And, there are limited circumstances where it will apply to private actors. And I don't think any of those circumstances are triggered here. Reddit, can readily get rid of whomever it wants to, and so can employers. In most cases, if you're an at-will employee or even someone with an employment contract where you can only be fired for cause, if you're doing stuff like this that your employer objects to, that probably, it certainly would apply in an at-will setting. They can fire you basically for any reason that's not otherwise barred as unlawful discrimination, and probably would even count as a for-cause firing. So, Jerry, we've gotten into, once again, the policy arena here, whether lawmakers should concern themselves, because I know that, the voting public is certainly concerned about the fact that this kind of thing can happen on the internet, and the voting public is equally concerned that there be the availability of free expression on the internet. So what do we do with a situation like this?
Well, I mean, I think at the moment that legislators get involved here and do anything to try to prevent this sort of thing, then we're definitely going to be in the First Amendment box, because at that point it is government that might be putting some restrictions. Right. I think what we're seeing right now is exactly what you would want to see, that a reporter like Adrian Chen, who, by the way, hats off to him, because he's really a master, number one, of reporting on internet culture in a way that very few people are. And number two, he's really a master at trolling the trolls, I think. And the way that he sort of fed out the tidbits that he was going to blow the lid on this little by little, really, and got the Redditors, as upset as they were that they banned Gawker or blocked Gawker, really drew a lot of attention to this. And so what's happening is, well, this guy has been exposed. He's lost his job. I imagine he'll probably be in some legal trouble later on, either criminally because of the nature of the pictures that he was posting, or from the subjects of these pictures suing civilly. So I really don't see much more here for government to do, because, look, this is exactly what we'd expect to see happen. I think the company, though, Reddit, the company, is going to have to walk a pretty fine line here, because Reddit users don't understand that distinction that you mentioned, Denise, about the First Amendment. And they think, and it's not that they, how do I put this? They believe, and it's their belief, and that's a great thing. They believe in free speech as an absolute. And Reddit is both a company, and Reddit is also a community. And that company is only around and profitable as long as that community is there. And if they start to sort of crack down on that absolute free speech that Reddit is known for, that community might go away, might go somewhere else. And so I think that's why Reddit sort of walks this fine line where, when there's attention, so last year when Anderson Cooper brought a lot of attention to the jailbait forum that Violent Acres had created, they shut it down. Right? So there's a lot of attention, Reddit shuts it down. But when there's no attention on Reddit, I think that they allow their community to do what it will.
And that's kind of what Reddit is and what it's all about. And if it were more sanitized, it wouldn't have the appeal that it has. And fortunately, I believe in our nation with the framework that we have. We've mentioned Section 230 of the Communications Decency Act already a couple of times on the show, and the DMCA, which protects it as a platform from copyright infringement occasioned by its users. With that framework, that regulatory framework that we have, the decision for what kind of content that Reddit may permit and what kind it shall prohibit is relatively straightforward. It could be as easy as saying we will allow anything to be posted on the site so long as that content itself does not violate the law. And it could even there's even a little bit of fudging that could be going on there, because it could permit that content to the extent that it is merely defamatory or something like that because of the immunity that it enjoys under Section 230. So it could draw that line all the way over as far as to say we will only allow content, or we will allow all content so long as it does not violate the criminal laws. For example, if it's child pornography or if it's some kind of terroristic threat or like that. So even though it is revisiting these issues and it is being more conscious of these things, the line lends itself very well to being easily drawn, and Reddit is certainly well within its rights and its ability, so long as it's going to keep the community happy, as you're talking, Jerry, to make that line drawing very, very easy, regardless of what the people who are watching CNN and watching Anderson Cooper might think.
Yeah, but as you pointed out, Evan, they the line gets blurrier when the person is actively involved in managing the content on Reddit, which I guess this fellow Violent Acres was.
So and then there's no shortage.
Starts to go out the window at that point.
Right, because it becomes the question becomes fuzzier of whether or not Reddit itself is a provider of the content, because that Section 230 immunity is only allowed for third-party content. So if the site itself becomes an information content provider, it does not enjoy that immunity under Section 230.
Okay, well, because Cash Hill's story on this is so good, Evan, as you pointed out, I'm going to have our second MCLE passphrase for the show come from her story, and it is Internet Cool Kids, who she describes as people who have favorite subreddits, Twitter followers in the 4, 5, and 6 figures, who Instagram their dinner parties, funny street graffiti, and sartorial choices, who were so into Turntable FM for a week, who were so into Pinterest for a month, who are falling in and out of love with Facebook all the time, who go to bed and wake up holding their iPhones, and who deal with trolls on a regular basis.
Oh, and they drink Pabst Blue Ribbon, of course. That's that's a critical element, but it's unwritten.
Yes, raise your hand if you're guilty of any of those. I think we probably all are a little. Let's move on to something slightly more serious and scary. Leon Panetta warning recently that we are confronting a cyber Pearl Harbor, and Jerry having a response to that. Jerry, can you please bring us up to speed as to what this cyber Pearl Harbor might consist of, and whether we all need to jump under the desk now or we can wait a bit?
Well, I mean, this is an issue that has been bubbling for the last couple years, where Congress has started to look at whether to pass cybersecurity legislation. And 2 years ago, when the first cybersecurity bill started being introduced, they were pretty serious bills that included things like licensing IT professionals, right? So you'd have to get a federal license before you could be a computer security professional. It would be all sorts of top-down regulation of networks. It would allow we had that famous, when Declan McCullough broke the story about the internet kill switch was a famous story. So, but since then, there's been a lot of attention paid to this. And there's been a lot of amendments to the bills. And so now it's more about information sharing between government and the private sector. The thing about it, though, is that throughout this whole period, when you ask why do we need these new laws, what you get from folks like Leon Panetta and Senator Joe Lieberman and Senator Susan Collins and many others in the administration and in Congress is this rhetoric of panic that we are going to have a cyber Pearl Harbor, a cyber 9/11. I've heard cyber Armageddon from certain folks. That basically says it's the bad guys, whether they be the Chinese, the Iranians, or Al-Qaeda, some even say anonymous, would be able to cause real physical damage here in the U.S. And the thing about it is, I mean, Leon Panetta said that we could have a cyber Pearl Harbor that could have consequences as dire as 9/11. And now here's the thing, right? At Pearl Harbor, almost 3,000 people died. And on 9/11, almost 3,000 people died. And you had massive destruction. The Twin Towers fell on 9/11. And, among others, the USS Arizona exploded at Pearl Harbor. What is the evidence that we could see that kind of destruction and death from a computer attack? And there really just isn't any evidence there. So while cybersecurity is a serious concern, and we should be concerned about cyber espionage and cybercrime, it is not the dire existential threats that we have to address immediately without asking questions, or else I
have a theory on this, Jerry.
Yeah.
That Secretary Panetta's just been watching too much nighttime drama these days. Maybe he's been watching Revolution or The Walking Dead. I mean, I think he's just seeing this post-apocalyptic world caused by the fact that all our computers go bye-bye.
I mean, that's one explanation. A more cynical explanation is that these folks want to have more power. The NSA would like to get its. I mean, and look, and quite frankly, in many respects, they probably want to do what's best for the country. And I think that the way to do that is to monitor all of our communications, to look out for these threats. Unfortunately, the temptation, once that exists, temptation is there to use it for other purposes, which is why we should be very careful. And I mean, there's also the temptation to want to regulate networks and tell them how to run their cybersecurity. And of course, there really is no evidence that the federal government knows how to secure networks better than the folks like Google who own their own networks, and that's what they do for a living. That's really their comparative advantage. So, while this is serious, and we should see, where there is an interplay between government and the private sector, we shouldn't be making policy out of fear. And I think that's a lot of what's happening here, right? You have a lot of defense contractors, for example, that stand to gain a lot if you do have regulation where then they would be in a position to consult or sell solutions. So, of course, they are selling these kinds of fear stories. Members of Congress, agency heads that would gain power and budget authority under an expansion of with cybersecurity legislation are using these stories to scare us, and I think we should say no. We know better, and we want to see the evidence. I mean, sometimes you'll hear saying, "Well, look, maybe they know something that we don't," and to that I say that's what we were told in the run up to the Iraq War. Condoleezza Rice famously said, "You don't want the smoking gun to be a mushroom cloud." And we trusted them, and they were wrong. Right. So, we should trust them, but we should verify and demand to see, what is the evidence that this is as dire as they say it is.
Jerry, I think that is it would be so hard to overstate the importance of what you said in that piece in the New York Times. I think that was just yesterday, right? Which was excellent. Everyone should read that, the opinion piece that you wrote there on that, about we shouldn't be making policy based on fear. And it's a complicated discussion to have. And folks like Leon Panetta are, that's an unenviable job that he has on any number of reasons. Because from one perspective, it's his job to make sure that we're safe, and he has to take a long view of history on this. He does not want to be perceived as the guy who was lax on this and lackadaisical and just kind of where we were sitting around twiddling our thumbs, not doing anything if indeed there is some kind of cyber attack, because there would be one if we're not vigilant about that. So from one perspective, it's very good that he's doing his job and protecting us from those things. And even if the consequences of him doing his job is that we have to tolerate some hyperbole and some rhetoric, that's hard to stomach. But at the same time, that rhetoric gets hard to stomach. And one thing that I fear a lot is that this is nothing more than just demagoguery and fear-mongering in a way to cover up a more serious political issue. That here's another one of those issues, Denise, that is not being discussed in the larger framework on all this: the expansion of NSA surveillance. And I think you mentioned it already, Jerry, in what you were talking about there. The Obama administration has not curtailed the Bush administration policy of expansive, wireless or warrantless wiretapping when it comes to that. It wasn't. There's been nothing in the debates. Of course, the president was on the Daily Show last night with Jon Stewart, and Jon Stewart, in some ways, was playing the role of Candy Crowley here, protecting the president from the answer that he would have given to the question that Jon Stewart asked about NSA spying. And he only allowed the president to say, well, actually, we have modified our practices. The president did not say that we have cut back on warrantless wiretapping or made the civil liberties safer. We have modified. And then the president said, these are not sexy issues. And then, of course, that led Jon Stewart to insert some comedy there. But he didn't go back to let the president talk anything more about that. They went on to the next issue without letting the president say anything substantive about this. So the whole point of that is this is a very serious political issue that has not gotten any discussion whatsoever. And at the same time, if we have Leon Panetta going out instilling fear in everyone, well, then why should we even be talking about it if the risk is so dire? If, my God, another 9/11 or another Pearl Harbor could happen. Who can argue that we shouldn't be doing everything that we can be doing here? So a terribly complicated issue that is of very critical importance, and it's hard to get into it and actually have a meaningful discussion about it that's not subject to being polarized one way or the other.
Right. The one thing I think everyone agrees on is they're terribly concerned with both points, both sides of the debate, that yes, they want national security and cybersecurity, and at the same time, they do not want the government all up in their business. This is sort of coffee shop talk anywhere that I go. I just sort of anecdotally, people seem to be really concerned about this. So, if you're going to legislate from fear, like you were saying, Jerry, you're certainly running the risk of civil liberties being tramped on right and left. And I agree. I'm not terribly optimistic that we're going to get the kind of transparency that you're calling for here, because they can always just cite national security and say, we're sorry, we can't do that. What do you say when that argument's trotted out?
Well, I think you just keep going back with the same. You put pressure on Congress and you just tell them, look, we can't have a blank check to the NSA and just say, trust them. I think Evan is right. Folks in Congress, folks in the administration have a lot of pressure because they don't want to be the ones who had a cyber attack happen on their watch, right? And so they're going to be calling for as much power as they can muster to sort of, the administration wants the power because it also comes with budgetary authority, and defense contractors like that too. Congress wants to be able to pass a law so they can say we did something, right? So that later on it can't be charged that, hey, you didn't do anything about this and then this happened. The problem is that while there is, again, there's a real concern here, what they do is that they use this rhetoric of we don't have time to talk about this. This is an emergency situation. We're going to have a 9/11, so let's just not talk about it. Let's just do this thing right now. Right? Again, this reminds me of the run-up to the Iraq War, and it makes me very wary. And what I'm trying to say in my writing is, well, stop for a second, just for a minute, and breathe, take a deep breath, and look at the evidence. Nobody has ever died from a cyber attack, ever, in the history of the world. So if that's sort of the evidence from history, I'm going to be a little skeptical when you tell me that at any moment 3,000 people could die. So pointing those things out and saying, let's have a serious discussion, right? And so if you look at some of the bills that are being proposed, they would allow for information sharing between the private sector and the government. And you can imagine, well, what's wrong with that? That sounds good, right? If most of the internet, the vast majority of the internet is in private hands, and the government might have some intelligence information that would help uncover and stop some attacks. Well, let's get them sharing information. The problem is that, number one, some of that information would be shared with DHS, some of that would be shared with the National Security Agency, which we have, because as you mentioned, Evan, with the warrantless wiretapping, we have reason not to trust completely. And we also have surveillance laws and privacy laws are there for a reason, right? They're there as a result of the Church Committee after the last time that the government abused its powers to surveil and to wiretap, right? And so we have these laws in place, and what these cybersecurity bills would do is that they would have a blanket sort of liability waiver for companies that share information with the government, and say if you violate, basically these privacy laws and these surveillance laws no longer apply to you. You have a waiver from liability if you're sharing information for the purposes of cybersecurity. The problem with that, though, is that we have these laws for a reason, and we can't just have one bill that just has a scythe, takes a scythe to all of those protections and just says, if it's for cybersecurity, those things are out of the way. No, if we do want information sharing, which is fine, we should have that, let's look at each of these laws. Let's look at ECPA and say, what is it about ECPA that's preventing this kind of sharing? And let's use a scalpel, right, not a scythe, to make tweaks and amend that law, bring it up to date, have the appropriate privacy protections there. That's what we should be doing, not just panicking. Take our time and do that, not panic and just pass one law that cuts away all those privacy protections.
I don't know. Yeah, David Pogue has a great show. I don't know if you've seen it on PBS. Watch it in case Romney is elected. It's Nova Science Now. I don't know if you've seen it. It's a great show. But there's an episode. I don't think it's new. I think it was just re-aired. But I caught it for the first time one night this week, where it was about hacking and some of the sophisticated techniques. And I guess with cars, automobiles, it's not impossible to hack into the system and affect the brakes or something like that. So maybe that's what we have to be concerned about. Al-Qaeda is going to do a distributed attack on our cars so that all one moment at least 3,000 automobiles are going to crash into one another or a brick wall or something like that. That's as plausible as it seems to me, but I guess it's still a reason to be vigilant so that it doesn't get to that point, you think?
Right.
Can I needle you a little bit?
I'll just add to that.
That's what I'm inviting.
If you one second, because let me throw something else on the fire.
Oh, sure.
If you listened to TWiT 375 last Sunday or thereafter with Cory Doctorow, he made the excellent point that we're getting to the point where our computer technologies are not on our desktop very frequently, and in the not too distant future here they're going to be in us, the hearing aids and other critical
pacemakers.
Yeah, exactly. Critical things that are run by computer and hackable. So, the 3,000 death things, either by automobile or internally planted device, don't seem to be that far away. Or maybe Secretary Panetta just knows something about weaponized mice that the rest of us are in the dark about. So close out these thoughts, Jerry.
No, I agree with that. I think we should just be much more deliberate about what we're doing with cybersecurity. And I think, I have some hope here because, after all, the Senate did not pass the cybersecurity legislation, and so we probably won't see that taken up again until next year. The president may well put out an executive order, though, which is problematic, but it's not as bad as one would think, though.
All right. Well, let us move on to our tip and resource of the week. Our resource of the week, I think you probably put this in, Evan, is a great infographic on Pinterest, the source of which I am unclear. It looks like something that you might find on Mashable, perhaps. The sources at the bottom say IT World and backgroundcheck.org. But
who knows where it came from since it was on Pinterest? It's
right.
It's hard to attribute it.
The host doesn't seem to be using the attribution linkback API here. Mike Johansson posted it. So tell us about this graphic, Solving Crime with Social Media. What can we learn here?
Well, just a neat little thing to look at about how, looking at law enforcement and crime from a couple of different angles. I think probably the most interesting one, well, they're all really interesting. I mean, we learn in bright graphic color detail that 80% of law enforcement use social media for their investigations in different ways. I mean, it looks like the biggest way is by identifying people in locations. And if you keep track of the different kinds of court decisions that come down in this space, you see that gang members still love to use MySpace for whatever reason. I think it's an observation I've made before. So people love to go and brag about the crimes that they've committed, and it's also a great way for law enforcement to interact with the community and get tips. We saw that in the Vancouver riots in 2011 after the Stanley Cup finals. An interesting point on this is at the bottom of the infographic. There are some reasons why some law enforcement agencies are not using social media in their investigations, and the biggest looks like the biggest obstacle for law enforcement not using social media in its investigations is that they couldn't access social media during work hours. So there's some kind of block. 37% of detectives, I guess, can't use Facebook at work because it's prohibited by their department protocol, which is that seems kind of unfortunate given the fact that there's such meaningful information that could be gathered to make law enforcement enforcement more effective from social media. You've got these admissions that people are just making all the time on their Facebook status update or their tweet or whatever, and that's just kind of writ large the inefficiencies of some law enforcement agencies.
I guess everybody gets to complain about IT.
That's right. Yeah, and it's a policy decision that comes down from usually a less informed perspective.
Right. All right. So our tip of the week has to do with dealing with negative online reviews. It's something I found over on FindLaw from internetReputationManagement.com. It's aimed at small law firms, but I think it applies to anyone. And basically, tips 1 through 4 on dealing with negative online reviews are do nothing. And or 1 through 3 are do nothing, and then 4 and 5 are contact the negative reviewer and see if you can reach out to them and fix the situation. So it's all designed to help you avoid the Streisand effect and to deal calmly and rationally with someone who is trashing or otherwise, monkeying around with your reputation online. So do check that out. There are some good tips there. And with that, we're going to go ahead and wrap this episode of This Week in Law. I've had great fun talking with you, Jerry, and with Joe when he was on that same episode of TWiT that I mentioned, episode 375, which actually has wonderful tech policy discussions as well. You should tune into that if you missed it. Larry Maggott, in fact, was talking about, there are basically two parties in Washington when it comes to knowing about tech policy, the clueful party and the clueless party, and there are Democrats and Republicans in each one. I was very honored today to have you and Joe staunchly representing the clueful party, and I don't know where Evan and I shake out in that. We're just, if there's a party, we're happy to be invited. So it's been a pleasure chatting with you today, and your work online is just so amazing and wonderful. I hope everyone goes and checks out not just your New York Times piece, but your extensive writing and your podcast, Surprisingly Free, where, as Joe mentioned, you've had Joe on, and let's see, we've had Nick Carr, Clay Shirky, Vint Cerf. I'm really hoping people go check that out. I know I'm going to.
Thank you. Surprisinglyfree.com.
That's great. Anything else you want to mention before we go ahead and sign off?
No, that's it. Thank you so much for having me. The podcast is a weekly show that we do. It's not a rundown of the week stories like This Week in Law. It is we have one guest. And we usually deep dive into one topic. And so, like you said, we've had Vint Cerf, Kevin Kelly, Clay Shirky, lots of good people. So, yeah, please check out Surprisingly Free.
Definitely will. Thank you so much. And thank you, Joe. Definitely go check out Joe's work at Center for Democracy and Technology. It was wonderful having him as well. And Evan, great as always chatting with you.
Great to chat with you. Let me plug something really quick other than the loopholes in my own thinking here. Our great, great friend, Ernie Svensson, Denise, you may be aware, this past week he got a mean letter from the American Bar Association because he had published an ethics opinion on one of his blog called PDF for Lawyers. And Carolyn Elephant, who is a well-known law blogger, has written a good blog post about that. And she has started an online petition to give to the ABA, showing how they're overreaching in their copyright principles on this, prohibiting lawyers from publishing ethics opinions. And I have a short URL that folks can go to, particularly the lawyers listening and watching. If you go to e74.us/PV, go there. That'll take you through to Carolyn Elephant's blog post about this brouhaha and has a link to the petition. The ABA is doing a disservice to transparency that would benefit all lawyers having better access to ethics opinions. It would help the practice of law. It would help the impression that people have about our profession if these things were more available. So I would commend any of the lawyers or legally minded people listening to go to e74.us/PV, Paul Very, and take a look at what's going on there in that controversy.
Oh, great. I was in the dark, so thank you for cluing me in as well, and we'll check that out. In the meantime, folks, we're going to be back next week at 11 o'clock Pacific, 1800 UTC. That's when we record this show live. You're more than welcome to join us at twit.tv when we do. We hope you will. But if you can't, you can catch it in all kinds of other places. You can find us at twit.tv/TWiL. We're on YouTube. We're on your Roku box. We're in iTunes. Go find us in any of those formats that most works for you. And do chat with us between the shows. Help us develop our content. Let us know what you want to talk about. Evan is Evan at twit.tv. I'm Denise at twit.tv. And you can hit us up on our Facebook or Google Plus pages for the show. Or on Twitter. Evan is Internet Cases. I am D. Howell. So we really look forward to seeing you again soon. And we've really enjoyed this great discussion today on This Week in Law. Take care.